So welcome to KMB Law's live stream today, and thank you to the Oakville Chamber of Commerce. KMB Law is a full-service law firm located in Mississauga, specializing in the areas of corporate commercial transactions, real estate, and litigation. I'd like to introduce my colleague today, Wojtek Jaskiewicz. Wojtek is the head of bankruptcy and insolvency litigation at KMB Law, and he also practices general commercial litigation. My name is Charles Lunn. I'm an associate at KMB Law, and I practice in the areas of general commercial and real estate litigation. So today, we'll be talking about the typical steps in a litigation matter in Superior Court and what happens if you get sued. So Wojtek, what should someone do if they are served with a court document called a statement of claim?
Well, the first thing I'd suggest anybody do if you're served with a statement of claim is to contact a lawyer. You have 20 days, or a minimum of 20 days, to file a statement of defense. And if you file a notice of intent to defend, you can get yourself an extra 10 days. And amongst lawyers, we can often work out extra time if it's necessary, if the matter is complicated. But at a bare minimum, you have 20 days to respond, and there are repercussions if you don't respond within those 20 days. The statement of defense is your version of events, your story explaining why it is that the plaintiff isn't entitled to whatever the plaintiff is asking for. What's important when you're drafting that statement of defense is to hit all the high points to make sure that you address everything that the plaintiff has raised, and also not to make any admissions that are going to harm you down the road. Once the statement of defense is ready, you serve it on the plaintiff and you file it with the court.
That's a great synopsis, Wojtek. What happens if someone fails to serve and file a statement of defense at all or within the court deadlines?
So this stresses the importance of responding to the statement of claim. After 20 days, the plaintiff is entitled to take out what's called a default judgment. If you don't defend, you're deemed to admit all the allegations made in the statement of claim, and the plaintiff can show up in court without you responding or having the opportunity to say anything further and get a default judgment. And the default judgment is a regular judgment, and it can be enforced in all the regular ways.
Okay, so if there's a default judgment, what can you do about the default judgment? Is that the be-all and end-all?
Thankfully, it's not the be-all and end-all. The rules of civil procedure, which are the rules that govern how actions progress in Ontario, do allow you to bring a motion to set aside a default judgment. You have to explain to the judge why it is that you didn't serve a defense within the time that's allowed, and you have to show that you have a defense on the merits. But it is possible. However, it's a costly process, and for that reason, it's best to just deal with the statement of claim within the time that's allowed.
Okay, so that's good news. Moving back to the usual course of litigation, if a statement of defense is served and filed, what's the next step after that?
The next step is to exchange documents. So your lawyer will prepare what's called an Affidavit of Documents, and the Affidavit of Documents is a list of all the relevant documents in the action. If you want to rely on a document at trial to defend yourself, you have to provide it to the other side beforehand, and if you don't, you can't rely on it. But in addition to that, what the rules say is that you have to provide all documents. So that means good, bad, or indifferent. If the documents are good for you, you want to provide them, but you also have an obligation to provide documents that are harmful to your case. The only real exception to this is documents that are privileged. So documents that are communications with your lawyers or settlement documents, you don't have to provide those. But the general rule is that all documents have to be produced.
Okay, so after this process of exchanging documents and exchanging affidavit documents, what's next?
The next step is examinations for discovery. So your lawyer will question the plaintiff to try and get facts that will help your defense and to try to undermine the plaintiff's case. And likewise, the plaintiff's lawyer is going to ask you questions about your defense to try to undermine your defense and to try and elicit facts that bolster the claim. Before the examination for discovery, your lawyer should sit down with you to prepare you for that examination. What that looks like is you'll review the pleadings, so the statement of claim, the statement of defense. You'll review all of the documents that were exchanged, and your lawyer should give you an idea of what questions you're likely to be asked at the examination. And then at the examination itself, your lawyer will attend with you and will watch out for questions that aren't appropriate and object to them. And to a limited degree, your lawyer can answer questions on your behalf.
Okay, perfect. So once documents are exchanged and the discoveries process is completed, is there a chance to settle the case?
Well, there's always a chance to settle the case at any point in the litigation. And in fact, in Toronto, 95% of matters do settle and don't end up going to trial. But there are two distinct moments in the litigation process where settlements tend to happen. The first is after the examinations for discovery are done and the matter is ready for trial, it's set down for trial, and the court will schedule what's called a pretrial conference. The pretrial conference is an informal meeting with a judge. It usually lasts between 30 minutes to an hour, and the judge will meet with the parties, express an opinion on the merits of the defense and the claim, and try to get the parties to settle. In addition to that, in Toronto, Ottawa, and Windsor, there's a program called the Mandatory Mediation Program. In those three jurisdictions, the parties are required to have a mediation. And the mediation is similar to a pretrial, but instead of a judge, you hire a third-party mediation, and it usually takes about half a day to a full day. What you do is you go over the case, the mediator will give you an opinion, and we'll try to work out a settlement with the parties.
Perfect. So it sounds like we're getting near the end of a typical litigation matter, perhaps. There is no settlement, and all pretrials and mediations are completed. What's the next step after that?
That's right, Charles. The next step is trial. So the plaintiff will present their case to the judge, their evidence, their witnesses, their documents, and likewise the defendant will present their evidence to the judge, and the judge is going to make a decision. And it's a winner-take-all decision. The judge is going to decide what side wins, and that side wins. There's no halfway at this point.
Okay. Can you still settle at this stage, at trial or after trial?
Absolutely. It's not that unusual to settle on the courtroom steps. Settlements can happen during trial as the evidence comes out and you see how the case is turning out. And even after the trial is done, sometimes settlements are worked out before the judge renders a decision.
Okay, so after a judge renders a decision and you're not happy with the results of the trial, is there anything that can be done about that?
There can. You can appeal a trial judge's decision to either the divisional court or the court of appeal. However, I should note that this isn't a new hearing. You don't get to present your evidence all over again. It's not a new trial. The court of appeal or the divisional court looks back at the decision that the judge made based on the evidence that was before the judge and decides whether that was the right decision to make.
All right, perfect. So the litigation process up to now sounds very costly and expensive. So what can you do about the costs, and what's the typical cost of the litigation process?
Unfortunately, right here, it's impossible to estimate what the typical litigation matter costs. It will always depend on how complicated the matter is, and almost to a larger degree, how the parties decide to litigate. But one comment I can make about costs is in Ontario, we have a loser pays system. And what that means is if you lose at any step, including at trial, the default is you pay 60 to 90% of the other side's fees. From a practical perspective, what that means is if you lose, you're paying all of your legal fees plus 60 to 90% of the legal fees of the other side. But it also means that if you win, you only get 60 to 90% of your legal fees back.
Okay. Well, thank you very much, Wojtek. You've been very informative today. And thank you to the Oakville Chamber of Commerce for this opportunity and for our viewers for tuning in. We will have a diagram posted up on our website at www.kmblaw.com on our resources page. The diagram will lay out the general litigation process and steps that we've talked about briefly. If you have more questions, feel free to contact us. Again, you have our contact information, www.kmblaw.com. Thank you very much again, and we hope you've learned how to navigate the typical litigation process, and we'll see you next time. Have a great day.
Thanks, Joe.